Hello everyone, Michael Mortimer here. I'm going to talk about some remarkable events in today's, the Zimmerman trial, in today's session that was in the morning. What usually is a fairly boring procedure, jury instructions, took place this morning between prosecutor I think his name is Manatee. I call him Manatee. Don West handled the preparation of the instructions and going over with them with the judge. And obviously there's Judge Nelson. Mark O'Mara and Bernie de la Rianda were not present in court today, as is typically the case when there's more than one attorney on the matter. The whoever has closing is usually absent during the jury instruction phase because they have to prepare their closing arguments. So Bernie is doing the presentation on behalf of the state. Mark O'Mara is doing the closing on behalf of Zimmerman. So they were at home or offices, wherever, preparing. Now what's going on here, and this will be the only part that I discuss about jury instructions, is that you have to be vigilant even in a process like this, because one side or the other, meaning the prosecutor or the defense, may try to slip something in or take something out of a jury instruction that will totally affect the deliberations and outcome of the case in regards to a verdict. Now, let me just explain really quick for those of you who are unaware. Jury instructions are the law of the case. When a jury, just before the jury goes into the jury room to deliberate, the judge charges the jury, tells them go back and deliberate, and then instructs them on the law. Now, some states, the judge reads the instructions and that's it. You have to remember them. Florida, which is where the Zimmerman case is, they provide a copy of the instructions to the jury. So they will have those with them during deliberations. Now, in regards to the law, the reason instructions are so important is because it can make a difference. For example, if the jury is considering murder 2, which they are in this case, there could be a lesser included offense, such as manslaughter, and any other charges that the state may want to have the jury consider. Now, what's going on here? Well, let me just tell you, give you an example. You have murder 2, you have manslaughter, and then you could have assault with a deadly weapon. All these are separate charges that a jury could find Zimmerman guilty of. It can be 1, 2, or 3 of them. So, in what's happening right now is that Prosecutor Manatee is arguing, or just got done arguing, that the state wants a third-degree murder charge considered, and it's, I believe, let's see, it's third-degree murder under child abuse. And what they're saying, what Manatee just got done arguing, is that because Trayvon Martin was under 18, he was a child under law, statutes, whatever. Therefore, when Zimmerman killed him, that constitutes murder, third-degree murder, because he killed a minor, a child. So that constitutes the underlying felony for this third-degree murder charge is child abuse. Child abuse can be a felony. So that's the argument. Nobody since day one has ever thought that this would be a charge. And Prosecutor Manatee whipped out these papers to support this instruction, including case law, and gave that to Don West. I think he gave it to him through an email. He said, oh, by the way, at 7:30 in the morning. So this is truly a surprise. And also gave that packet of materials to the judge. So everybody's surprised by this. But does that mean it can't be argued? No. So Manatee got done with his presentation on justifying why this third-degree felony murder charge, child abuse as the underlying felony, should be in an instruction and a charge that the jury can consider finding George Zimmerman guilty of. Okay, and sorry to talk this way, but I have no notes. I'm just ad-libbing from, I'm actually just looking at what you're looking at. The video still, I paused the video, of Judge Nelson sitting there on the bench with her mouth open. So I have nothing to refer to. So if I sound, what's the proper term? Using slang and poor grammar and slurred speech, that's the reason why. All right, now, again, I thought this was interesting to present for two reasons. It's instructional for the lawyers and the law students of my seminars who need to be instructed, and the best way to instruct students and lawyers is by way of example of real life situations. They need to be instructed that, look, when you get to the tail end of trial, it's almost done, everybody's focusing on opening and closing and what the evidence showed and all these things that constitute the trial. When you get to the tail end of all that, and again, we started with opening, actually jury selection, then opening, then presentation of the state's case, presentation of the defense's case. Now we're here, closing arguments coming up, and we're dealing with these instructions. You cannot let down your guard. And this is an illustration of why, because this came up. And the judge did not say, hey, wait a minute, this is a last-minute thing, and this is what Mr. West is going to argue, what you will see. You can't rely that the judge will say, you can't spring this stuff up at the last minute like this. This is improper. You should have brought this up to the court's attention, arguably before opening statements, so that everybody can proceed on the trial addressing this prospective charge, which certainly the defense would have done. They would have put on evidence to refute, dispute, contest a child abuse charge, and they would have tried to bring in certain evidence and whatnot. Okay, so watch the judge's reaction in terms of her saying, because Mr. West is going to argue about this, and notice whether or not she says, yeah, it's kind of the last minute, so I'm not gonna entertain this instruction. I'll give you a little hint. She doesn't do that, and so this has become very serious. And let's see, what was the other thing? Mainly, I want you to, this is used as an illustration of why you can't let your guard down when you're getting to the instruction phase. A lot of lawyers do. they're busy with everything else. There may not be more than one lawyer on the case. So instructions are something you just don't pay attention to because you're busy. You got other things to worry about. And so here's what can happen. All right, let's press play.
Thank you. Mr. West?
Oh my God. Just when I thought this case couldn't get any more bizarre, the state is seeking third-degree murder based on child abuse? Is the court going to give this any serious contention or consideration? Because if so, we have a lot of talking to do. We can start with Mr. Manatee dumped all of this on us sometime around 7:30 this morning. There was an email, oh, by the way, we've changed our lesser included request from aggravated assault to third-degree murder based on child abuse, and put 10 or 15 cases that obviously he has spent hours, if not days, if not in fact maybe more than a year plotting for this moment when he can spring it on us and the court. Somewhere we wondered why the state would put this vague allegation in the information that Trayvon Martin was 17.
The information that he's referring to, that's the charging document for the civil lawyers and the law students listening to this. The information in a criminal case is the charge. It's just like in a civil case, there's a complaint that's filed by the plaintiff. In a criminal case, the prosecution is equivalent to the plaintiff in a civil case. And the information details, here's the allegation supporting the following charge. So George Zimmerman was charged with second-degree murder, and the state attorney, who is sitting in the background here, I'll point her out, she put in there, here's the following facts to justify a second-degree murder charge. Now, what Don West is talking about is in that information, I recall, I believe all they mentioned was that Trayvon Martin was a 17-year-old. That's all they put. And nothing else about him being a child and this being the basis for a third-degree murder charge / child abuse. Nothing. And they go through the entire trial, the entire case. I believe the information was filed in April of 2012. And here we are in July 11, and this comes up. So that's what Mr. West is taking exception to.
No other charge of child abuse, no evidence of anything other than this statement that Trayvon Martin was a minor, 17 years old. First of all, I move to strike it as surplusage because it's not related to any element of the offense for which George Zimmerman is charged, nor related to any conceivable lesser included offense. So I guess what's happened now since the time that the state filed its information in...
Okay, let's see, I don't think I clicked it so that my cursor would show up. On the right here, on your screen, on the right is Prosecutor Manatee, whatever his name is. He's the one that made the motion to, or the argument to have this new instruction with the adding third-degree murder, child abuse. To the left here, the handsome fellow, that's Prosecutor John Guy. He is he's the one with the voice. If you close your eyes and listen to him, he sounds exactly like Kevin Costner. So he will be giving the rebuttal closing tomorrow, Friday, July 12. Right here in the middle, in the back, that is Angela Corey. She is the boss of these two prosecutors, And whereas before, during trial, etc., she was sitting here on the left, the woman in the white coat, in the gallery with the victims, Trayvon Martin's family, parents. She was sitting there. But now she has moved up to uh, this additional counsel table in the background. And I believe we'll be able to hear her kind of barking instructions to Mr. Manatee here on the right um, at some point. And so that's kind of interesting just because she's just like shouting what he should say, and you usually never see something like that. But this table is only so big, so she has to sit back there. And just so you know, on the far left with the woman in the white coat and the orange top, that side is the Trayvon Martin family side of the gallery. On the right side, all those people are media, and in the front row that you can't see, that's where the George Zimmerman family is. Okay, let's proceed.
April, that they've been lying in wait, collecting all this loosely connected child abuse case law where 2-year-olds have been shot by someone who was reckless with a gun, or some child exposed to horrible deprivation or abuse resulting in death. Just so at this moment, on the day of closing arguments, we would have to deal with it. Well, I can say it's certainly consistent with the way this case has proceeded since April,
I had to laugh.
but it's certainly just as disingenuous as well. This is outrageous. It's outrageous that the state would seek to do this at this time in this case. Now, if the court wants to recess for several hours so we can research and review these cases, draft a memo of law, we can do that, and we certainly are entitled to the opportunity to respond in a meaningful way.
Okay, now this is a good argument by Don West. One of the things that you have to do and pardon me for using the word things, I'm just speaking off the top of my head, so I could say arguments or whatever. One of the arguments you have to make on appeal is that there was a suitable record and objection at the trial court level, establishing all your points and arguments to the court as to why you objected to whatever. So here, Don West is arguing to the court why this he should be given an opportunity to respond properly, thoroughly, to the and substantively to this material that obviously, as he says, Mr. Manatee has been preparing over the past year or whatever, lying in wait to spring this on the defense at this last moment, the day of closing argument. That's probably accurate because I think he cited Manatee's provided 10 cases, and this is all a polished presentation. I think he even had a bulleted PowerPoint presentation. And like I said, I wasn't going to include this because it just makes it too long with my talking here. But he had a bulleted PowerPoint presentation and whatnot that indicated to the court, to Don West, everyone, that this was prepared for a long time. So the importance of this right here is that Mr. West is establishing prejudice to Mr. Zimmerman. You have to show prejudice by the conduct of the opposing party counsel. Otherwise, the appeals court will go, well, so what? Yeah, he didn't do the right thing, and whipping this out at 7:30 on the day of closing argument, that's not really nice. But you haven't shown us prejudice. How was your client prejudiced by this conduct? So Mr. West knows that has to be shown for an appeal if Mr. Zimmerman is convicted, you bring all matters of appeal, all issues of appeal, because you never know which one's going to stick with the appeals court to where they say, reversible error, we're granting a retrial, which means everybody gets to do all this all over again. If you don't show prejudice, then the court's going to go, well, so what, and harmless error, and whatever other terms they use, and not kick it back, not find reversible error. So that's why Mr. West is going into such detail on the record about the prejudice that his client is suffering as a result of their actions, the state's actions.
But it's just hard for me to imagine that the court could take this seriously. Certainly the court wasn't provided with the case law either, nor given any hint that this is where this was going to go.
Well, in all due respect to that statement, the court hasn't been provided a lot of things that have been requested to have hearings that the court has had up until late in the evening, until the last minute, or I requested of it. So that in and of itself is not an argument, and I don't want to go there. So let's go on to the argument about this instruction.
I'm not prepared to make an argument. This was just emailed to me, buried in the set of instructions that the state's obviously been working on for months and months and months, just to spring it on everyone at the last minute. Mr. Manatee has this fully formed, organized argument based upon all this case law that I guarantee you he didn't come up with between yesterday, when they wanted aggravated assault, and this morning, when they now want third-degree murder based on child abuse. Really? Ms. Corey's sitting right there, apparently approving of this.
That's not proper argument.
It's
Okay, the court is totally correct. You never, ever, and lawyers, a lot of you know this unless you're fairly new lawyers and you haven't got into court that often, haven't appeared in court. And law students, I know you don't understand this concept, but pay attention. You never, ever even hint. I'm trying to think of the way to emphasize this. You never badmouth the court. You never show disrespect to the court. And what Mr. West has just done was badmouth the court. Basically said the court's in cahoots with the state. Now I'm going to pause this video and I'll rewind it and play that for you again so you can see what I'm talking about. And this is why the judge and Don West, the attorney, are at odds with each other. They are like, what's that phrase? Water and oil. They just don't mix. There is a mutual dislike of each other. Don West has no respect for this judge. Judge Nelson has no respect for him because he doesn't have any respect for her. And she really doesn't like when he shows the court disrespect. So Don West is Don West. He is who he is, as the saying goes. I agree with the judge completely that he is out of line, and he's done this before. You can see my other videos on this, where I think I said Don West goes MMA on Judge Nelson. So let's play this again, and this is instructional. Okay, I'm going to play the beginning of Mr. West's argument to the judge so that you can get everything in context and when he steps over the line. Notice that he is just the kind of lawyer he is. He's very passionate, very emotional, emphatic with his points, the argument that he's making, and he just starts going. He just gets consumed with his argument, and he doesn't think about what he's saying, and in this particular situation, how he's addressing the court. This is just wrong. And he's lucky that the court has not called him to task on it. And if he was, well, actually, I don't know the law in Florida, but in federal court, here in California, I'm in San Francisco, California, in federal court, a judge probably would have sanctioned him by now, imposed a fine, found him in contempt of court, and more importantly, is after everything's concluded, after the jury has reached a verdict and the trial's over, a federal judge still retains jurisdiction over the lawyer and could very well, for example, after everybody clears out and Mr. West and they got their not guilty verdict and everybody's kind of in a celebratory mood, the judge could say, Mr. West, I would appreciate if you contact me next week by this time, and if you want to approach, I'll tell you why. Or if the judge doesn't want to spare him the embarrassment, could just say it from the bench to where he's at a counsel table and say, there's going to be an order to show cause why you should not be sanctioned and your conduct reported to the bar for your display of disrespect throughout the course of this trial. And you are ordered to appear on Monday at 9 a.m. and I will give you the parameters of what I expect you to discuss, where I'm going with this, what I'm thinking about, and we'll go from there. And then Mr. West might say, well, Your Honor, can we just talk about it now? And the court could say, no. You will come in Monday, and that's when we'll talk. For now, go out with your client, celebrate, have yourself an ice cream cone. As some of you know about that controversy, have yourself an ice cream cone, and we'll see you on Monday. And for all I know, the judge in this case could do the same thing. So even though Mr. West has kind of gotten away with this today, and he got away with it the other day, that doesn't mean the court lost jurisdiction over him, and it's like, no harm, no foul, and no big deal. Okay, so let's watch this one more time.
Really? Ms. Corey sitting right there apparently approving of this.
That's not proper argument.
It's not fair to me, it's not fair to Mr. Zimmerman or Mr. Romero or the court for this to happen like this right now. I need time to sort this out if the court is going to give any consideration to this remarkable suggestion by the state that somehow third-degree murder based upon an 827, Chapter 827 and Chapter 39 violation of the child abuse statutes could somehow, when Trayvon Martin is shot straddling George Zimmerman, pummeling him, that somehow George Zimmerman was engaged in child abuse?
Now, I don't know if the judge is looking at a page of a case on her computer monitor right now, or if she is just trying to cool off. She realizes the world is watching her. Everybody that's kind of paid attention to the case is now tuning in. Everybody that has taken a keen interest in the case is tuning in. The entire world is watching. And she is on center stage. She is the judge. So I suspect that she is like, I've just got to cool off. I've got to count to 10. I think she's counting to 10. We can together look at her eyes and let's see if it looks like she's reading something or if she's just kind of staring at the screen pretending she is reading something and just counting to 10. Okay, let's see.
In the Supreme Court's jury instructions that are online and in the rules of criminal procedure book.
I'm going to play that back because I'm curious about the eyeball. Let's see what kind of movement there is. I could be wrong on that, but not that it's a big deal. But I'm sure you're as curious as I am now. Was she counting to 10 or actually reading something? And of course, she could be multitasking. She could be doing both. Okay, I'll just play this on a little rewind here.
Like this right now. I need time to sort this out if the court is going to give any consideration to this remarkable suggestion by the state that somehow third-degree murder based upon an 827, Chapter 827 and Chapter 39 violation of the child abuse statutes could somehow, when Trayvon Martin is shot straddling George Zimmerman, pummeling him, that somehow George Zimmerman was engaged.
I think I didn't go back far enough. Okay, let me quickly do that. Again, this is primarily instructional for the lawyers and law students taking my seminars on trial tactics, so that's why I want to go back on this. And let's look at the judge's eyes. And as a reminder, as we all know, that those of you who have been in court and trial, we always look at the judge's mannerisms, eye movement, what the judge is doing with his or her hands, grabbing a file, writing something down, getting distracted, because that tells us what effect our points and argument are having on the judge. If the judge seems like she's just grabbing the papers and setting them aside, you know, oh, I better come up with a different argument because the judge seems to be closing the book on this particular issue. And I had that happen one time. The judge was talking to me and he grabbed the file and he started to hand it to the clerk. And then I kept saying, Your Honor, there's no evidence. Your Honor, there's no evidence. And I watched the judge. And the reason I was saying that was because I saw the judge handing the file to the clerk. And as I kept saying, Your Honor, there's no evidence, that rung a bell in the judge's head, thinking, oh yeah, there's supposed to be evidence from the other side to support this injunction. They wanted a restraining order and an injunction on a business, basically, that would have put the business, my client, out of business. And as I was saying this, I watched the judge halt his handing the file to the clerk, brought it back, put on the bench, and opened it up again. So I thought, thank God that, you know, I changed my tactics, changed what I was saying, changed my emphasis so that the judge would not rule and say, no, I'm granting the injunction, because that's what the judge was about to do. And by the way, the judge did not grant the injunction or the restraining order, and so that was lucky. And why? Because I paid attention to what the judge was doing. All right, let's see here. And again, we're looking for the judge's eye movement after Don West badmouths the court. Says you're in conspiracy, practically says you're in conspiracy, in cahoots with the state.
Mr. Manatee has this fully formed, organized argument based upon all this case law that I guarantee you he didn't come up with between yesterday when they wanted aggravated assault and this morning when they now want third-degree murder based on child abuse. Really? Ms. Corey sitting right there apparently approving of this.
Okay, I may stand corrected. And that's why you have a court reporter and a record created on all court proceedings because the who knows what was said, and it's important to get every word down. And also, this illustrates why video and audio court records, which some courts have to save money, are not adequate at times, because here I thought I heard Don West say this court. I believe, now playing this slowly, I heard him say Miss Corey. And again, the state attorney, who are the bosses of these two prosecutors in the front desk, is right in the middle of them in the back, and her name is Angela Corey. And I think what he is saying is that Ms. Corey is approving of this conduct. Now, the court would take exception of this because Mr. West's conduct, because you also should not attack lawyers. Personal attacks are never allowed in court. You shouldn't call your opposing counsel stupid. You shouldn't call them unprofessional, incompetent. Personal attacks are not allowed. And courts will cut you off if you attempt to do that, which, if this is in fact what Don West just said, the court's going to chastise him, saying that's not proper argument. Now, it could be Ms. Corey also, because notice Guy, John Guy, on the left, the one who sounds like Kevin Costner, notice he's got a little grin on his face. I submit the reason is because Don West has gone over the edge, and he knows that now the judge is going to get mad because of what he just said. And just as a side note, apparently Ms. Corey, as Don West said, again, that's the state attorney right in the middle there, and Judge Nelson are personal friends. So, I don't have any proof of this and whatever, but Ms. Corey has been attacked by Don West, and the judge, for many reasons, is going to consider that improper. But also, Don West just attacked her friend. That's not nice. Okay, so let's proceed, and I'll quit delaying on this. I'll try to keep this under an hour so that we can just get through it. All right.
That's not proper argument.
It's not fair to Mr. O'Mara or the court for this to happen like this right now. I need time to sort this out if the court is going to give any consideration to this remarkable suggestion by the state that somehow third-degree murder based upon an 827, Chapter 827 and Chapter 39 violation of the child abuse statutes could somehow, when Trayvon Martin is shot straddling George Zimmerman, pummeling him, that somehow George Zimmerman was engaged in child abuse?
Again, on the eyeball movement that I just saw, I do not believe the judge was looking at the case. It looked like her eyes were moving all over. So I think she's just trying to cool off. Now we've got to play just this part. So let me pause it, and I'm going to slow down the video so we can figure this out. Now it's a mystery to me. So you'll just have to bear with. If you want a refund on all this, you know what? Fine. I'm just gonna a little dry humor there, but okay. Let's see. Let me pause this, and I'm gonna play this back, and let's watch the judge's eyes, because I think she's just trying to cool off. Okay, I lost my place, but I think I'm absolutely correct. If you look at her eyes, she goes down, she goes up, she goes down, she goes up. So let me play that for you, but I just wanted to let you know that I kind of cheated here and played it in slow motion and looked, And I think I'm right. She's just trying to cool off. She's counting to 10.
Fully formed, organized argument based upon all this case law that I guarantee you he didn't come up with between yesterday when they wanted aggravated assault and this morning when they now want third-degree murder based on child abuse. Really? Ms. Corey sitting right there apparently approving of this.
That's not proper argument.
It's not fair to me, it's not fair to Mr. Zimmerman or Mr. O'Mara or the court for this to happen like this right now. I need time to sort this out if the court is going to give any consideration to this remarkable suggestion by the state.
Okay, watch your
That
eyes.
somehow third-degree murder based upon an 827, Chapter 827 and Chapter 39 violation of the child abuse statutes could somehow, when Trayvon Martin is shot straddling George Zimmerman, pummeling him, how George Zimmerman was engaged in child abuse?
Okay, let's see. She looks up, down, sideways. And look at that glare from Don West.
The Supreme Court's jury that are online and procedure books indicates that the offense charge of second-degree murder, a Category 1, is manslaughter. The Category 2 is third-degree felony murder, vehicular homicide. Non-homicide lessers would be an attempt, culpable negligence, aggravated battery, aggravated assault, battery, and assault. These are part of the jury instructions that have been known to this court since I've been on the bench.
Did
So
the court ever for a second think we were
I'm not
going to be-
finished speaking.
I'm sorry, I
please.
apologize.
Thank you. The
Good call.
possibility
apologize.
of a Category 2 is known to counsel at the beginning of the trial.
In the same way we would expect vehicular homicide be offered?
But the
It's-
evidence doesn't support that, and the state's argument is, at first yesterday, when they provided the court with the possible lessers, and one of them was aggravated assault, I didn't have any information available to me that led me to believe that that would be a charge that would be given, because the facts did not support an aggravated assault lesser included offense.
Yes.
Their argument today is that the facts support a third-degree felony murder with the underlying enumerated felony being child abuse.
Okay, I was going to say final point, but I won't tell you that. This is very, very important, what you're seeing right now. The judge, whenever you're in court, and lawyers that maybe you have 10 years experience but not a lot of court time, pay attention to what I'm about to say. Law students especially pay attention to this. Always listen to the court and what the judge is telling you. Judges will always tell you what they are having a problem with, what issue or issues they are concerned about, what facts are important to the consideration of the issue before the court. They will always tell you. They don't just simply in a situation like this, well, I'm going to grant the motion or include the instruction and leave it at that, especially when you have counsel such as Don West making a major argument, serious argument about this denies my client due process, violates the Florida and federal Constitution, etc. The judge has to articulate reasons why she would grant this instruction. So what this judge has done, because she, in my opinion, she's a fair judge. She does not, even though some people say, oh, she's biased in favor of the state, and no, she has been fair and down the middle on a lot of her rulings. Sometimes she gets it wrong because she's ruling on the fly. She has to make a ruling right then and there, and sometimes she gets it wrong. That's fine. Everybody's like that. We lawyers get it wrong sometimes. Judges do too. So she is going to tell Mr. West, here's where I think you should go in terms of an argument, not to hell, but in terms of an argument. And if you address this issue, then I probably will not include the instruction. In other words, she helps him out. So it's always critical for you to pay attention to what the judge is telling you, regardless of when the judge is saying whatever she's saying. Pay attention. When the court speaks, pay attention.
That is permissible under the statute. If you need I'm not gonna give you hours. You have, I don't know how many lawyers you have working with you on this case. Well, you have 4 in the courtroom, and I know there's a room downstairs full of people who.
Ms. Truitt's a lawyer, and Mr. O'Meara is a lawyer. That's who we have as lawyers on this case. Everyone else is a volunteer, an intern who has really done remarkable work, but we can't rely on non-lawyers to do the kind of work that's necessary right now. Judge, this was a trick. Doesn't the court realize this was a trick by the state?
My intention right now is to.
Okay. Another illustration. One of the things that, and there I go using the word things again, one of the aspects about attorney Mark O'Meara, that's the other counsel for Zimmerman, the main counsel, Ms. Truitt in the background there. She's just been there in the sidelines of background. But Mark O'Meara has a real problem in terms of style, in my opinion. He is always telling the court what she needs to do. You need to do this. You have to look at that. And at one point early on in the case, the judge said, please don't tell me what I need to do or what I have to do. And O'Meara apologized. Oh, sorry, Your Honor. And then he was right back to it. Well, the court needs to understand this and look at that. Now here's Don West doing the same thing. And the judge just doesn't like that. And she is 100% right. You don't tell the court what they need to do. You don't tell the court they've made a mistake. You can say the court may not be aware of this case or that case, or I would like to bring up to the court that there's this case in the event Your Honor has not seen it. You don't tell the court, well, obviously you don't see this as a trick. You don't say it like that. Okay, let's see. I want to play that out again. Since this is instructional for how you behave in court also, I'm going to pause and play that one more time. Okay, here we go.
Vehicular homicide be offered?
But the evidence doesn't support that, and the state's argument is, at first yesterday when they provided the court with the possible lessers, and one of them was aggravated assault, I didn't have any information available to me that led me to believe that that would be a charge that would be given, because the facts did not support an aggravated assault lesser included offense.
Yes.
Their argument today is that the facts support a third-degree felony murder with the underlying enumerated felony being child abuse. That is permissible under the statute. If you need I'm not gonna give you hours. You have, I don't know.
She caught herself. She was about to say, if you need a moment, which, trust me, on paper that would look absurd. For the court, I think he cited 10 cases, the prosecutor cited 10 cases in support of the instruction. So for the court to say, well, if you need a moment to look at 10 cases, that would be, ridiculous.
How many lawyers you have working with you on this case? Well, you have 4 in the courtroom, and I know there's a room downstairs full of people who...
Ms. Pruitt's a lawyer, and Mr. O'Meara's a lawyer. That's who we have as lawyers on this case. Everyone else is a volunteer, an intern who has really done remarkable work, but we can't rely on non-lawyers to do the kind of work that's necessary right now. Judge, this was a trick. Doesn't the court realize this was a trick by the state?
My intention right now is to get through the rest of the jury instructions, because if we have any arguments about the others, I would like to get them resolved. We will come back to this one. I understand your argument. We will come back to this one.
Again, in the proper way to address the court, show respect to the court and the judge. And by the way, I'm assuming that the law students out there, when I'm talking about the court, I mean the judge. Okay, I hope I don't have to explain that part. If I do, then I don't know. Maybe I'll give you a D in class. But anyway, the proper way to act with the court, when the court, and usually you don't say he or she, but when the court said, let's move on to other matters and blah, 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 you say, thank you, Your Honor. You acknowledge the court in some way. I can tell right now, without seeing Don West, that he's just standing there steaming. He's not sure what he's going to do. And the deputies, kind of jokingly, I'm saying this, but the deputies are on full alert, hands on guns in case, and pepper spray in case Don West just decides to start throwing things. All right, so here, let's...
They also proposed, I think it is required that the court instruct as to the justifiable and excusable homicide, just as we do with second-degree murder with respect to the third-degree murder and the manslaughter, so that has also been included. The next, I guess, area of discussion moves to the justifiable use of deadly force instruction.
Okay, I'm there. I have both in front of me.
At the court's request, I did attempt to incorporate much of the proposed language from the current.
Okay, I'm going to find a place because I recorded this in two separate videos. I'll find the spot on the recording where the third-degree felony murder, child abuse instruction is picked up again in terms of discussion. Okay, I want to, this is out of context in terms of, in regards to the instruction brouhaha over the third-degree felony murder hyphen child abuse as the underlying felony. Mr. West is going to make an excellent argument over, or the state wants to add a definition to the self-defense statute, attempting to define for the jury what constitutes substantial injury or injury, whatever. The reason this is important is that self-defense does not require to prevail on self-defense, you do not have to show injury. You just have to be in fear of injury. What I always use as a analogy is the swinging bat analogy. If somebody is swinging a baseball bat at you, you do not have to wait for that person to hit you with the bat. You do not have to suffer physical injury before lawfully defending yourself. You can shoot the person dead if they are swinging a bat at you. What the state is attempting to do with this jury instruction modification is include a definition of injury, the real intent being that they want to imply with innuendo that Mr. Zimmerman has to have been injured, and in regards to those injuries, they had to have been substantial in order for him to prevail on self-defense, his self-defense theory. This is sleight of hand, this is trickery, this is smoke and mirrors that the state is trying to pull. And this is the reason I bring this up is an excellent illustration of why you have to be fully alert and diligent when discussing jury instructions. If you're in a hurry, you may say, oh yeah, okay, a definition can be included. But Don West is fully experienced in these matters. I think he used to be a federal public defender before getting into private practice, and so he knows full well the import of these various instructions and what they might imply. So that's why he's not falling for this gimmick that the state's trying to pull. So the court has just heard Mr. Manatee's argument as to why a definition under self-defense defining substantial injury or serious injury, whatever, why that is a proper definition to include. And now Don West is going to argue, wait a minute, no, this is not proper. And I just like the way he's presenting the issue, and you can see how if you're experienced, you know what you're doing, you are able to respond like he does just now.
Well, there are multiple. First of all, the context of the cases cited not appropriate for the context of the state seeks in this case. There is no definition in the justifiable use of deadly force instruction for a reason, because the Supreme Court decided it didn't need to be defined beyond that within the common understanding of those terms by the jury. The state is seeking to shift the focus away from what everybody knows is great bodily harm and why that's in the instruction. And the reason it's in the instruction is this: it's not that Mr. Zimmerman sustained great bodily harm or great bodily injury himself. That is a completely irrelevant issue in this case.
Where in your proposed instruction does it have a definition of great bodily harm?
It doesn't. I gave the language that the Supreme Court used. That's the standard instruction. The Supreme Court does not define great bodily harm in the standard instruction for justifiable use of deadly force.
But the state is saying that this authority, Chestnut versus State, as previously cited, Coronado versus State, 654, Southern 2nd, 1267, Florida 2nd, DCA, 1995.
Now watch
Gordon versus State,
Attorney
36,
West get all
Florida Law
upset
Weekly,
again.
D2590, Florida 3rd, DCA, 2011, which cites to Owens versus State, 289, Southern 2nd, 472.
Look at his expression.
2nd, DCA, 1974, and C period A period C period versus State 771 Southern Second 1261 Second DCA 2000 and when NGUYEN versus State 858 Southern Second 1259 First DCA 2003.
Has the court read those cases?
I just see the synopsis. I do not have those
Right,
cases.
and the synopsis is the one provided by the state?
Correct.
Yes, and it's not correct.
It's actually a quote, so.
No, these aren't self-defense cases. These cases don't deal with the definition of great bodily harm in the context of the self-defense instruction. For example, in Chesnoff, the 14-year-old victim was attacked by another, and he was punched, I guess, and kicked, and that he had swollen lips and a swollen head, so swollen that his mother didn't recognize him the next morning. The jury got the instruction of basically severe harm or great bodily harm, and the jury found Mr. Chesnoff guilty of that offense, based upon the very thing that Mr. Manatee suggests should be trivialized in this case. That is misleading and not appropriate in this case. Likewise, to suggest to this jury by any definition of great bodily harm like this one, which frankly is legally wrong, and we object, would shift the focus of this jury not from what Mr. Zimmerman thought was happening, which is the standard the jury should apply, but to what actually happened to him. And it's a mischaracterization of the law, it's misleading, and this is just plain wrong for the jury to have, factually and legally. As the court is well aware, there are no injuries required whatsoever for self-defense. Mr. Martin didn't have to lay a hand on him if, indeed, Mr. Zimmerman reasonably believed that the use of deadly force was necessary to prevent the imminent commission of great bodily harm. Everybody knows what great bodily harm means when you're punched in the face and your head is smashed on concrete. The state's expert said there are at least 3 impacts on concrete by Mr. Zimmerman's head. That is Dr. Valerie Rao. There's no issue there. She said as much. She saw the bruising, the collection of blood.
Notice Mr. West's oratory skills. He is a master at legal argument. I posted his closing argument on the experts issue, and you can certainly look that up, and just a superb performance. What is remarkable about his style is that he has no notes, and he's just speaking off the top of his head. Notice that he doesn't have any ums and uhs and no pauses. He just talks like he's reading a script, and of course he's not acting like he's reading a script in a dry way. He has inflection, he has emotions, he has drama in his words when he's talking to the court. And yes, that's right, arguably too much drama at times, but this is where he shines. On paper, his words just look excellent. It looks like if you saw this argument on paper, on a transcript, as a court reporter would produce it, it reads like a term paper, like he spent a month writing it. And it's just excellent style. So just wanted to point that out. We could all hope to achieve this ability. I certainly can't, but that's just me.
Under the skin, she saw the lacerations. Dr. DeMaio opined further, having seen additional injuries, further increasing the number of the minimum times that Mr. Zimmerman's head would have impacted concrete. What the state has been trying to do from the beginning is somehow shift this not to what somebody going through what Mr. Zimmerman was going through at the moment must have felt that when you have your head banged against concrete and you're screaming for help and the person beating you doesn't stop and no one's coming to help, that that's a reasonable basis to believe that you're facing great bodily harm. Just because he didn't die, just because his skull wasn't fractured, just because he healed up relatively quickly, doesn't mean that he didn't have that fear and that reasonable belief at the moment. The state is asking the court to deviate from the guideline, from the jury instructions with something specific that doesn't apply, that's not an accurate statement of the law or a definition that has been approved in self-defense cases. This is treading on very thin ice for this court. Very thin ice for the court under these circumstances to instruct this jury on something that just isn't the law.
Ms. Swan?
Actually, I disagree.
The standard jury instructions for any.
Now, here's another interesting aspect. Well, obviously, I've been talking for over an hour, so I consider all this interesting. But for you students and lawyers that don't have much experience, I believe here is where the court cuts off the prosecutor and just rules. She is thinking, we've got to get to closing arguments, and the jury's going to be in here in, I think, an hour or so, and we can't be doing this. I'm not going to listen to all this and give each side their just to go over and over and over and argue. We got to get through this. So I think this is the one where she made up her mind on this particular instruction and the modification that the prosecutor is seeking. She just cuts him off and says, I'm not including it. In other words, Don West won on this particular instruction, where the prosecutor was attempting to add a definition to it that implied that the Mr. Zimmerman, to prevail on self-defense, had to show serious physical injury, which just isn't the law. You just had to think that you might be suffer serious injury.
Defense, self-defense, aggravated anything. There is no definition anywhere. That's the reason the courts have given it. Self-defense isn't sort of some special circumstance. The fact is, the phrase great bodily harm is used in an instruction, whether it's in the self-defense instruction or whether it's in connection with another instruction isn't the point. The point is the court said, Chesnoff and Coronado and all these courts said, the standard jury instructions provide no definition of great bodily harm. And that's anywhere. That is the reason they approved the court giving the jury some guidance as to what that might be. I will first point out that Mr. West is not correct that any doctor said injury X must have come from getting your head, I think as he put it, hit on the concrete or mashed on the concrete. What they said was, it is possible, it is consistent with that happen, it is equally consistent with getting struck by any hard object, including a fist.
Please don't interrupt each other. But I'm going to interrupt.
Yes.
You have to take each of these proposed jury instructions and the special instructions that are being requested by either side and weave it into what the evidence shows so the jury can be instructed. Your argument that you just provided to me has two different sides of the story. That's the jury.
And this is for lawyers who can follow this stuff. This is humorous. The judge is about to say, you're talking through both corners of your mouth, or however the saying goes. You're talking in circles, and your argument in that circle is you're saying one thing at 6 o'clock, so to speak, and at 12 o'clock you're saying something else. Then you're coming back to 6 o'clock and saying it a different way, and sometimes the same way you said it 2 arguments ago. So the judge is about to tell him, wait a minute, you're being ridiculous, and just ends this.
To decide which one they believe, whether the injuries were consistent or they were not consistent. The instruction that you're seeking to have entered says that great bodily harm is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple assault and battery. The testimony before the court, whether the jury chooses to believe it or not, that's their purview, is that you don't have to have any injury to be in fear to the extent of the justifiable use of deadly force.
I agree with everything the court said, and that's why the argument wasn't quite finished. What we're talking about here is the defendant's reasonableness of his fear. If his fear is only that he's going to get a fist beating, for example, that is something that the jury should know in relationship to the definition of great bodily harm. In other words,
I find this definition akin to what I've just stricken from the defense request, that they want me to instruct them that the Florida law is it's not illegal to follow somebody. I find this akin to that. So I understand your argument. You have it all on the record. I've cited the cases that you cited to me in support of them. They're on the record. Unless you have further argument about that, I'm ready to roll.
Well, especially, the only further argument I'll make on it is this, especially since I believe that we should include the aggravated battery sections as relates before, especially since I think those should also be included. Most certainly, this definition should be included,
Okay.
Judge.
Well, I've already struck those, so that's not an issue. Okay, the court is not going to give that special instruction. So is there any other special instructions being requested by the state?
Okay, let me put you on pause and just get to the discussion about the felony, third-degree felony murder, underlying felony child abuse. Okay, just to illustrate my point that I made earlier, that everyone makes mistakes, counsel, the judge. This is a minor mistake in appearance, in other words, how it went over in court. But think about how it looks on paper, and what the judge, I might as well not couch it in mystery. The court says the only issue we need to take up when we come back after the recess is the second-degree murder issue, which he meant was third degree. So while that doesn't sound like a significant error, the fact is the court reporter takes down every word that's said, and on paper it's going to say the judge said that we're going to bring up the second-degree murder charge. So that's not what's on the table. She has to make a decision on the third-degree felony murder charge. All right, let me play that for you just to show, hey, everybody makes mistakes.
Before we recess for lunch, let me give you a schedule thing. Yesterday, Mr. West, you had indicated, or I don't know if it was Mr. O'Mara, I'm getting into a housekeeping issue. You had sought to introduce into evidence Defense Exhibit D, and that was the portion of a tape played in front of Miss Gentile. And the court had indicated that my notes reflected that that tape was played to Miss Gentile outside the presence of the jury. And I asked the court reporter to check her notes, and the email that I got back was,
she hasn't made the mistake yet.
Immediately after lunch,
I'll just play this
Mr.
through
West
rather
asked
than trying to
questions
rewind it.
regarding the, quote, you want
Or
that
fast
too,
forward it.
end quote, part of the tape. And that was played to Miss Gentile outside the presence of the jury. When the jury was brought back into the courtroom, Mr. West used that issue. So the court will not be admitting D into evidence that was not played in front of the jury. As far as
Okay, here we go.
goes, I know the jury's supposed to be back at 1. I know that Mr. De La Rianda wants to get the jury instructions settled before he does his closing argument. I'm going to say that we'll be in recess until 1 o'clock. I will take up the second-degree murder argument, and thereafter Mr. De La Rianda will be given some moments to get his, but that would be the only thing he would have to plug into his closing argument, and we'll start the closing arguments for the state this afternoon.
I'm sorry, the third-degree murder argument, Your Honor?
The third degree, I'm sorry.
Thank you.
Manslaughter will be given.
Who's taking responsibility for finalizing the set of instructions?
Well, the state's gonna do it,
All right, and I'll be.
and we'll review them,
Okay.
okay? So we'll be back at 1 o'clock and be prepared to argue the third-degree murder instruction. I think all the other instructions.
Okay, this also illustrates another point. You never, if you have knowledge, you never let the court make a mistake without bringing the error to the court's attention. In other words, if this benefited you in some significant way, that the judge mixed up second degree and third degree, say for example later on you said, but Your Honor, you acknowledged that we were going to discuss the validity of the second degree murder instruction. Let's say that you were reading it and you said to yourself, gee, if I could change the wording on this second degree murder charge, that would help on the instructions, that would help my client. So you decide to go into the court and misrepresent that, well, Your Honor, you did say that on the record that we will be discussing the second degree murder charge and the instruction. So let's discuss it. And the court says, well, no, I meant third degree. You're never allowed to take advantage of a court's error, and if you're aware of it, you should bring it to the court's attention. So the prosecutor did the right thing. He said, well, you mean third degree. And the court said, oh, yeah, that's right. So don't ever let the court make a mistake and continue on with that if you know that the court has made a mistake. Okay, let me find the other video. Okay, it's after the recess, and they're back in court, and as the court had said earlier, before the recess, we'll take up this third degree murder charge, the underlying felony being child abuse. We'll take that up after the recess. So here we are. The prosecutor, in my opinion, improperly brings in 2 more cases to cite to the court, gives copies to the court, gives copies to opposing counsel, Don West. That's really, in my opinion, that's unheard of, that you just keep piling on stuff to the court and to opposing counsel, just whip this stuff out. And the general rule, well, it's not even a general rule, it's almost a hard, fast rule, is you make your argument, you cite your cases, and that's it. You don't keep bringing up stuff. So to have a recess, and then this counsel goes and the prosecutor finds some more cases and brings them in and gives them to everybody literally a minute before court is called again, that's just sleight of hand, that's trickery, deceit, and you shouldn't do it. Don't ever do that. But let's see how the court handles all this.
Well, likewise, as the court, I just got these cases as we came in here a couple of minutes ago. I certainly haven't had a chance to read them or do any follow-up.
I don't need you to do that. I went back and I looked at all this, and I don't think that the evidence supports a charge to the jury for third-degree felony murder on a child abuse charge, so I'm not going to give that instruction. So I have received your final draft, so it's...
And that is the end of that. The court wants to move on after the recess, and they came back, and right now the closing arguments are supposed to start. So the judge wants to move on, and obviously this surprise third-degree murder charge, child abuse, could be argued for 2 to 3 hours if the judge let that happen. So she's just saying, you know what, this is it. I'm going to make my ruling, and she just cuts everybody off, Don West, and says, look, I don't need to hear your argument because I have ruled.
It's not so final yet. The change that would need to be made is on the lessers to take out the third-degree felony murder. And then we can just excise out the
This is pretty humorous. And I just want you to notice the prosecutor John Guy on the left, the one who sounds like Kevin Costner. Notice that he has wiped the smile off of his face. The prosecutor who made the argument for this additional charge is sitting there like, I always say that he makes expressions like he's a dodo bird. Not that I know what dodo birds look like, but I know what they look like in cartoons. And he just has the oddest expressions, like something's going on in his head. Well, notice he's just like sitting there and like he's not sure what to do because he doesn't like that the judge summarily cut him off. And as far as him making this charge, and she's like, well, I'm not going to do it, and that's the end of it. So he's sitting there like Don West has always done. Don West hates when the judge makes a ruling against him, and he wants to go on and on and on and fight with the court. Now it's Prosecutor Manatee's turn, and he's thinking, oh, what do I do? I can't be like Don West and argue with the court. And then he's also thinking, and actually not argue, but fight with the court. So he's thinking, well, I better make my record, especially since I can feel my boss's burning eyes on the back of my neck. And that's, again, his boss is Angela Corey, who is the state attorney. These two in the front, they're called assistant state attorneys. Out here on the West Coast, you know them. In New York, you know them as district attorneys, and then you have deputy district attorneys or assistant district attorneys. Depends on what the jurisdiction is. Out here in California, they're mostly deputy DAs. I think up in Oregon they call them ADAs, assistant district attorney. But anyway, so the person in back with the grimace on her face looking at the computer, that is their boss, and you can tell she's pissed too. So this guy's thinking, oh no, what am I going to do? So let's listen in, and then I'll end this video.
Charges, and I don't have, and you'll finalize the verdict form.
Yes, sir, we will.
I understand your argument, but
I was only going to ask which part of shooting the child hadn't been established.
Now, another thing for you inexperienced lawyers and law students, the formalities of this are very important because it affects substantive matters, substantive issues. And what the court has done is issued a ruling on the instruction that she is not going to include that definition that the state wanted to have inserted. The court has ruled. Legally speaking, what the prosecutor is attempting to do is reopen the issue to have the court reconsider the ruling that she just made. So it's interesting that now he is doing exactly what Don West has done at times. Don West sometimes does not take no for an answer. So now it's the prosecutor's turn. He does not want to take no for an answer, so he's saying, well, Your Honor, can you tell me what part of my brilliant argument you're not accepting? I thought for sure I won this. Matter of fact, we all had lunch, and we were just guffawing and laughing how I was going to get this in, and now you're telling me I lost, and oh my God, now I'm going to have to buy lunch for everybody because I bet them that, well, anyway, I digress. Here we go.
well, I just don't think that the intentional part of that is there for the child abuse charge, and it's not alleged in the information that way. And I just don't think that the...
Excuse me on the part where I mentioned the definition. They were trying to slip that in. This is the additional charge that they were trying to get added for the jury's consideration.
evidence supports that. And if I'm not sure about that, I'm not going to charge the jury on it. And I think that to exercise caution, I'm going to deny that being set before the jury.
Understanding that since it's objected to, any error that's been established as reversible will be deemed waived. I hope that we at least protect the record in that regard.
Okay, thank you. So with that being done, are there any objections to the proposed final draft of the jury instructions?
Okay, that's it. I'm going to end the video. Hope you enjoyed this and felt it beneficial and instructional. I recommend that you play it a number of times because there's a lot of lessons to be learned by watching this video. Not only paying attention to each aspect of the litigation process and especially trial, remaining vigilant, staying awake. Don't think that anything is a minor issue and you don't need to pay attention to it. And also how to properly address the court. You don't badmouth opposing counsel. You don't badmouth the court. You don't show disrespect to the court. And figuring out, like listening to the court, what the court's saying, what problems they're having, what issues there are, because that can be extremely beneficial in tailoring your argument and a response and possibly changing the court's mind if something is adverse to you. All right, Michael Mortimer signing off.